These are appeals in the matters of Wirral Council as administering authority of Merseyside Pension Fund and Indivior PLC and Reckitt Benckiser Group PLC.
Yep.
My lords, my lady, I appear with my learned friend Mr. Barton for the appellant in this matter. My learned friends Miss Davies, Mr. Singler and Mr. Scott appear for the respondent Reckitt, and my learned friend Mr. Patton appears for the respondent Indivior.
Yep.
My lord will have before the court a core bundle, a supplementary bundle and a combined authorities bundle.
You don't seem to be
No, it's not running. Your time's not running.
Ah.
despite having been told we were. This is what happened last week. Exactly what happened last week with Opus 2. Sorry, Mr. Chairman.
No, not at all, my lord. I'm sorry that the technology has
Is
let us
this
down.
going to work today?
It will come on. There's a recording going at the moment, so anything that isn't on the real time will be
Yeah, but
transcribed that day.
it's quite useful to have real time. We're supposed to have it. It's quite useful to have it at 10:30 on the first day of the hearing. And for Opus 2 to have been in court before the hearing begins, making sure that everybody in court, including the judges, is logged on. I have wasted so much time with Opus 2 failing to do this job. Right. As long as we've got a transcript that's running somewhere, so we don't have to take a detailed note of the manuscript, that's fine. Here we go, it's up. Good. Right, thank you very much, Mr. Chapman. Not your fault.
I'm grateful, my lord. It's with a little trepidation that the last piece of housekeeping I was going to mention was whether the court was minded to take a break for the transcript.
No.
Right.
No, rather like the Master of the Rolls, I'm disinclined to give a break for transcript. There are usually at least two transcribers they can switch over.
My lord, so be it. We will work on that basis. My lord, as recognised in the order of Lord Justice Mells granting permission to appeal, this appeal, we say, gives rise to an issue of principle, which is or is likely to be of general application, namely whether securities actions of this type, brought pursuant to the statutory regime imposed by sections 90 and 90A of the Financial Services and Markets Act 2000, can ever be pursued by way of representative action. Given the judge's reasons for striking out the representative action here, we say, with respect, the decision may have even broader consequences beyond securities actions, as on the face of it, if a representative action is not to be permitted here, and not to be permitted for the reasons given by the judge, then it is difficult to see in what circumstances a representative action might ever be permitted, particularly where the claim gives rise to individual or claimant-specific issues. If that is right, we submit that the decision below would have a seriously limiting impact on the availability of the representative action procedure. As to this last point, the representative claimant here has sought to adopt the procedure which we say was expressly approved by the Supreme Court in Lloyd and Google. What it seeks to employ is the bifurcated process contemplated by the Supreme Court's unanimous decision in that case. Namely, first it seeks declarations resolving certain common issues in the claims under Section 90A and against Indivior alone, Section 90 of the Act. And second, and only if declaratory relief is obtained, then those declarations would provide the represented persons with a binding judgment on the common issues and a basis upon which to bring their follow-on claims for damages based on their individual circumstances as to causation, where relevant reliance, quantum, and where an issue limitation. In Lloyd, the Supreme Court explained why such a bifurcated process in a representative action is appropriate, fair, and moreover in the interests of justice. And on the basis of the judgment below, it has effectively been found that the position which the Supreme Court suggested was of general application does not apply and cannot apply in securities actions of this type.
No, it wasn't. Well, that wasn't decided, because what the judge said was that if you went ahead with the multi-party proceedings at a case management conference, you might persuade the judge hearing the case management conference to bifurcate the proceedings, much as had happened in a number of the earlier securities claims, including the ones which my lady dealt with.
Well, my lord,
This wasn't a sort of all or nothing situation.
well, my lord, we say it was an all or nothing situation when it comes to the ability of the smaller investors to bring claims at all.
Where's the evidence of that?
Well,
Where's the evidence where is the evidence from the funders that they are not prepared to fund the retail investors?
well, my lord,
Something that's happened in lots of other cases, and as my lord pointed out, RBS is a case where there was funding retail investors.
well, my lord, I'll come to that if I may, but RBS was a case that did not have the same claimant-specific issues as the Section 90A claims here. And when it comes to the evidence, I'll come on to show, if I may, that there was ample evidence before the judge below to support the finding that we say he should have made, that by depriving the representative persons of the ability to bring the representative action, they would effectively thereby deny them the ability to seek redress at all. And I'll come to that if I may. But there was evidence below, and I'll show the court what that evidence was.
Mm-hmm.
And Lord, we do say that on the basis of the judge's findings here, then the practical effect of the judgment is to say that a representative action is not available for this type of claim. And we say in doing that, the judge erred in principle and that he misunderstood and misapplied the learning to be taken from Lloyd. And we do say, as I've just indicated, that for very many of the representative persons, this is an all or nothing case. Effectively, the costs and risks of a multi-party action price them out of seeking redress. And it's for them the representative action or nothing. Now, my lords, my lady, with that introduction in mind, I was proposing to structure my submissions as follows. Mm-hmm. First, I was going to set out how we say the judge misunderstood and misapplied the law, particularly as it's to be found in Lloyd. And the ultimate conclusion of those submissions will be that this is a paradigm case of the type contemplated in Lloyd, where the existence of the same interest is not even disputed, and a clear bifurcation between the common issues and the individual issues is possible, and where there is obvious efficiency in determining the common issues first.
Right.
And we say, in particular, the judge misdirected himself because he did not grasp the significance of Lloyd, dismissing it as obiter and providing only, quotes, in passing treatment of the representative action. With respect, we say that that starting point infected the rest of the judge's analysis right through down to his case management points, where he effectively treated the claim, the representative action, as one seeking an exception to what he regarded as the conventional orthodox manner of case managing securities actions. So that's the first part of the submissions. The second point is to seek to rise to the challenge that my lord has just set me, and that is to demonstrate why the use of the representative action here, as explained in Lloyd, is efficient and will maximise access to justice. And as part of that, I will need to take the court to what we say was the material before the judge to show that employing the representative action makes it economically viable for investors, including retail investors in particular, who have legally good but financially modest claims, to bring those claims in a way that the traditional multi-party action simply does not. And I'll come on to develop this point, but we do say that it is significant that this is the only Section 90A claim where it appears that he's willing to fund retail investors, but is only prepared to do so on the basis of the representative action. And flowing from that, we will submit that unless the effect of depriving those investors of the representative action can be explained away, then that point alone is likely to be a powerful point, and ought to be a powerful point in the exercise of discretion. And the judge sought to explain that position away effectively as a contrivance on the part of the funder. And I'll come on to take the court to why that was wrong. And then thirdly, and most shortly, I'll address why the judge was wrong to object to the representative action and to the bifurcation proposed on the case management grounds that he did. And effectively, in summary, the position there, we say, is that the judge was wrong to characterise and thereby to mischaracterise the Lloyd type bifurcated claim as ousting the jurisdiction of the court. And beyond that, to the extent that the judge based himself on the various case management or practical points, then they are all matters that would or could have arisen in the Lloyd type case, but which did not trouble the Supreme Court in Lloyd.
He talks about it ousting, which perhaps is a rather emotive way of looking at it, but the reality is that the effect of what your clients are doing was to present the court with a fait accompli in circumstances where, in a normal case, the court would have the case management decision to make as to whether to bifurcate or not. And that was the point he was making, I think. I don't think it was any more than that. He may have put it, as I say, in slightly emotive language, but I don't think it was intended to be any more than that, really.
But my Lord, with respect, we say that the emotive language provides an insight into the judge's reasoning and rationale.
With respect, either you were depriving him of the case management power, or you weren't. And if one looks at the thing objectively, you were depriving him of the case management power.
Well, I'll come on to develop this point, but in summary, my Lord, what we say is that it's wrong to think of it as depriving the court of case management powers. The representative action and the multi-party action are two different forms of procedure, each with their own case management regime. And the judge's flaw was in viewing this as some type of comparative exercise where the representative action was some type of exceptional course to be taken because of the different case management landscape to which it gave rise. Whereas we say, on a proper understanding of Lloyd, in fact, the representative action, while it does provide a different case management regime, is none the worse for that. It is simply a different procedure by which a claim can be advanced.
Mm-hmm.
So, my Lords, can I turn, my lady, turn to the law? As you all know, but it perhaps bears repeating, the representative action is brought pursuant to CPR Rule 19.8, formerly Rule 19.6, as we'll see in Lloyd, and the single jurisdictional threshold that must be met before a representative claimant may bring such a claim is the same interest requirement, and there is no dispute that the representative claimant satisfies that jurisdictional threshold here. Where the same interest requirement is met, then the representative claimant can bring the representative action as of right. There is no need, for example, for the representative claimant to seek the permission of the court, as might be the case in other procedural regimes. However, and although this does not necessarily spring from the express wording of the rule, we accept, as was made clear in Lloyd itself, that the court then has a discretion whether to allow the representative action to continue or not as a representative action. What the rules do make express provision for is a mechanism for directing that a person may not act as a representative claimant. So a directed inquiry as to the appropriateness of the particular representative claimant acting as such, and that's under rules 19.82 and 3.
But I think you accept that that's not just limited to if there's going to be a representative action, are you a suitable representative, but should there be a representative action at all?
My Lord, yes, we accept that, and that falls to be considered as a matter of discretion.
Yes.
I'll come on once we've looked at Lloyd and Prudential and my Lord's own judgment in Commission Recovery to try to sketch out what the parameters of the discretion might be and what one should be looking for before one, to use, I think, my Lord's words, stops the action in its tracks. So that brings me to Lloyd, which is in the authorities bundle at tab 12. So volume 1, for those working in hard copy, tab 12, page 243. As the court will know, this was a unanimous decision of the Supreme Court, with the judgment being given by Lord Reckitt, with whom Lord Reid, Lord Arden, Lord Sales and Lord Burrows agree. And can I spend perhaps just a little time, I know the court will be familiar with the decision, going through the judgment and its contours. And can I invite the court to begin at page 252 and paragraphs 3 and 4, please, actually 3 to 5. Because paragraphs 3 to 5 set the scene. And then perhaps I can also invite the court just to read paragraph 8, which provides a summary of the outcome.
I mean, what's striking about paragraph 5 is that Mr. Lloyd was saying that there was no need for individual assessment of damages, that each effectively it was an argument that he could deploy the same, as it were, the same regime as in competition cases of aggregate damages, and divide it all up between the individuals. They didn't. Hence the suggestion that maybe 750 each, and that approach was ultimately rejected by the Supreme Court, wasn't it? Because they actually didn't allow this to proceed.
My Lord, that's right, and that's the outcome to which I referred that's summarised in paragraph 8. And
that's not an approach which you're advocating in this case.
No, I mean, in paragraph 8, as we'll see, it says that Mr. Lloyd's case was doomed to fail precisely because he sought to claim damages on behalf of all members of the class without individualised assessment. Right. But as we'll also come on to see, the Supreme Court indicated that had Mr. Lloyd sought to employ the approach that the representative claimant Wirral seeks to employ here, of a bifurcated approach, seeking declaratory relief first and then individualised assessment of damages second, then that would have been a permissible approach for Mr. Lloyd to have taken. And that's why I start with paragraphs 3 to 5 and paragraph 8, because we accept, of course, that everything else that follows and upon which we rely is obiter. Mr. Lloyd's case failed because he was trying to do something different to what the representative claimant in our case is seeking to do. What the representative claimant in our case is seeking to do is to follow the guidance in Lloyd as to what the Supreme Court thought would be permissible. But Mr. Lloyd's claim failed for the reasons we've seen in paragraph 8. And it is important to recognise that starting point, that everything else that follows is obiter, but nonetheless, not least because it comes from unanimous Supreme Court, and a unanimous Supreme Court that has taken the decision to set out in detail the landscape of collective redress in English law, and in particular to provide detailed guidance as to how representative actions might be used in the future. It is very powerful guidance that ought to be followed, and we say was not followed and dismissed too lightly by the judge here. Now, having seen that starting point, Lord Legman moves to collective redress at paragraph 24 of the judgment, page 257 of the bundle. And he deals with the available forms of collective redress in English law. And I will take this relatively quickly, unless the court wishes me to slow down, but just drawing attention and placing emphasis on particular features as we go through the judgment. So the judgment begins with group actions, and group actions brought by way of group litigation order under CPR Rule 19.11. And it is right to acknowledge that one of the perceived disadvantages of the group action with a GLO that was identified by the Supreme Court in paragraph 25 is that, as one sees about midway through that paragraph, the group action procedure suffers from the drawback that it is opt-in, an opt-in regime. In other words, the claimants must take active steps to join the group. And then there's reference to the administrative cost of that. Now, as the court will know, the procedure contemplated in this action is an opt-in process, where the opt-in process is part of the class definition, but the administrative burden of dealing with that is something which the representative claimant and its funder is prepared to meet. And so while the opt-in nature of group litigation is identified in this paragraph as a perceived disadvantage of the group litigation order regime, it is not a disadvantage here. It is also right to acknowledge at paragraph 26 that the Supreme Court identifies that another limitation of opt-in proceedings is that experience has shown that tends to give rise to low participation rates on the part of those with a claim.
Yeah, well, that was Morrison's, wasn't it?
It is. And another disadvantage or perceived disadvantage identified at paragraph 28 is that the need to prove loss on an individual basis does not or can have the effect of not making the procedure cost effective. So the GLO regime is identified and various limiting factors identified with it.
Don't all those factors apply in this sort of case as well?
Well, my lady, they might, and they might apply in any type of Lloyd bifurcated procedure that is on an opt-in basis. And one has to weigh the potential downside of an opt-in process requiring here shareholder investors to actively subscribe to the class.
But to an extent, the opt-in is not a separate point from the need to prove individual loss. I mean, as you accept, individual loss would have to, and indeed reliance would have to be proved here. It's quite hard to see how it wouldn't be opt-in on some basis.
Well, that was the next point I was going to make. It's quite difficult to see how the representative action could be structured other than an opt-in process. But one of the advantages of an opt-in process here is that, first of all, there has to be a degree of scrutiny on the part of the representative claimant's advisors, and for that matter its funder, as to whether those opting in satisfy the requirements to join the representative class. And secondly, because the represented class is capable of definition at any point in time, then that means that the members of the class are capable of being identified to the defendants and indeed to the court. And that's something that was addressed in the evidence here, that the members of the class would be identified to the defendants. And indeed, jumping ahead, there was also the offer to provide trading data without prejudice basis, if that would be helpful to the defendants in analysing the class. So I have to draw attention to the potential limiting factors identified by the Supreme Court of the opt-in GLO procedure. But when we come to, first of all, considering the features of the opt-in procedure here, but then also considering how the opt-in procedure works in a bifurcated structure as contemplated in Lloyd for a representative action, actually the advantages of representative action become very plain. So one has to see the opt-in nature of the representative action in context, and the two points of context are the particular features of the representative action here, and secondly, that it's opt-in in a representative action structure rather than opt-in in a GLA structure. And I'll come on to explain why, in the context of the representative action as contemplated in Lloyd, that is helpful.
There's no reason why a GLO structure couldn't have been adopted for claims under section 90 and 90A, is there?
In principle, my lord, I think the answer to that would be no. The judgment deals next with the second form of collective redress procedure that is available in English law. That's collective proceedings. That is, as the court will know, a bespoke procedure of its own and a creature of statute that is not available more generally. And then at paragraph 33 at the bottom of page 259 of the bundle, the judgment moves to the representative action. And what follows is a detailed analysis of the historical foundations and use of the representative action over the following paragraphs. And if I can seek to summarise what's said there, the first point is that it is identified that the representative action has existed for several centuries, but historically had been used by relatively small groups. Periodically, the courts had taken wrong turns and sought to restrict the availability of the procedure. But where this had happened, it had then been corrected by the House of Lords. So one sees, for example, at paragraphs 40 and 41, at page 262, the wrong turn or misstep taken in Temperton and Russell, which imposed a somewhat restrictive approach to the use of the representative action, being repudiated and corrected by the House of Lords in the Duke of Bedford case. And at the bottom of that page, one sees citation of the speech of Lord Macnaghten, which emphasises that the representative action is a simple rule resting upon convenience. And over the page at 263, a phrase to which Lord Leggatt, I think, returns, that it was better when approaching these types of procedure to go as far as possible towards justice than to deny it altogether. And we say, as I've already indicated, that that's where, among other things, the judge went wrong here in effectively denying a route to justice for a group of the represented class. And to like effect, one sees at letter C on that page reference to John and Rees, where it was said that the representative rule is to be treated as being not a rigid matter of principle, but a flexible tool of convenience in the administration of justice. The historical survey of the ground then continues with arguably another wrong turn, certainly in terms of what was said about the availability of declaratory relief in Marked. And then at paragraph 47, Lord Leggatt turns to prudential assurance. And I should probably pause and just invite the court to read paragraphs 47 and 48, please, because I'll have to come to look at Prudential. But in our submission, the fact that the Supreme Court describes Prudential as important in demonstrating the potential for a bifurcated process was something which, again, the learned judge overlooked. And I'll come to look at Prudential after Lloyd, if I may, but I simply invite the court at this stage to note the importance given to that decision by Lord Leggatt in tracing through the historical foundations of the representative action. And as we'll come on to see, there are some quite striking parallels between Prudential and the present case. And of course, the judge effectively dismissed Prudential as a different case where the representative action was permitted at the outset of trial. And so the case management issues with which he was concerned did not really arise. And the court will understand why we say that that was an error. The judgment then moves to the question of claims for damages. And this is obviously an important section of the judgment. And here, Lord Leggatt makes clear that the representative persons may have individual claims for damages requiring individual proof, but that will not operate as a bar to a representative action going forward. And one sees that in particular at paragraph 55.
Yeah.
And then the judgment goes on to consider the Court of Appeal's decision in Flies and British Airways, where the representative action was struck out on the basis that the way in which the class had been defined meant that the issue of liability would have to be decided before it could be known whether or not a person was a member of the represented class and therefore bound by the judgment. But helpfully at paragraph 58, Lord Legge has identified that the case in Emerald could have been brought on a bifurcated basis, with common issues being determined first and matters of individual loss and causation and so forth being determined at a second stage. And that's set out at paragraph 58.
That seems to contemplate that the first action, the representative action, stops with a declaration, and then there are separate actions, follow-on actions. Is that what's contemplated by your proceedings?
Well, we identified for the judge, although the judge was somewhat critical of this, that there were a number of different ways in which the stage 2 of the proceedings could be taken forward, and those options themselves appear from the authorities. So, for example, in this part of the judgment, what seems to be contemplated, as my lord identifies, is that the representative action would seek and obtain the declarations, and that there would then be further proceedings after that by which individual claimants relying on the declaratory relief would seek to prove their individual claims for loss and damage. Now that was a possibility, if and to the extent that one spells out of that the represented persons would then bring separate claims by way of new claim forms, was the possibility that, as we'll come on to see, was canvassed in Credential as well. Now, an alternative...
It all depends on whether the claims for damages are individual claims, which have to be assessed individually, or whether, for example, I mean, the reason why the representative procedure, including claim for damages, was appropriate in the insurance cases like the Irish Rowan, is because you've got a group of underwriters underwriting the risk with set percentages. You calculate, amongst other things, what the total loss is for which they're going to claim against the whole group of representative defendants, and then you just divide it up according to the percentages. So you can see that in that sort of case, representative proceedings might very well be appropriate, because the truth is that although this is probably heterodox, you can regard it as like a claim for liquidated damages. And there are authorities that say it isn't, but that's how it works, as you know. But where you have individual claims for damages, as would be the case here, the position is very different. Really, by getting the declarations, you only get, as it were, part of the picture, because you've still got to establish reliance, causation, and loss.
My lord, that's right, and we don't shrink from that conclusion. And we say that that's effectively what is expressly being contemplated would have been the case and would have worked had it been advanced in Emerald. And as we'll come to see shortly, but
sorry, just to pick up on that, really picking up on my lord's point, you couldn't use these proceedings as currently constituted in order to get damages claims of the individual claimants.
So how you've got multi-party proceedings stayed for the institutional investors, and you could see that after a declaration was obtained in the representative proceedings, could be the stay could be lifted, and they could proceed to trial. What's the position of the individuals?
well, the position of the individuals are dealt with by three alternatives. One is new claims, which was what was canvassed in Credential and seems to be canvassed here in discussing Emerald. New claims brought by way of new claim forms. And then there would be an argument to be had as to the effect of the representative action on limitation. But
Indeed, they would.
and that's obviously an argument, so to speak, down the line, because the position has yet to be determined. Relatedly, a second option engaging similar concerns or similar issues would be that the representative persons could apply to be joined as parties to the multi-party proceedings. And the third alternative,
So the first alternative is fresh proceedings.
yes, fresh proceedings by way of new claim, a new claim form or claim forms, and that's the procedure that was indicated could be adopted by the other shareholders in Prudential, and appears to be what's being indicated by the Supreme Court in the discussion of Emerald here. The second alternative would be for the represented persons to apply to be joined as parties to the multi-party claim forms on the assumption that the stay is being lifted.
But limitation also raises.
And that's why I said that would engage the same issue as limitation, where the position as to the effect of the representative action on limitation for the represented persons is a matter which is yet to be resolved. There's some discussion of it in the Supreme Court's decision in Lloyd, but the position is yet to be resolved. And the third alternative, which was what appears to have happened in the New Zealand case of Credit Suisse and Houghton, to which the Supreme Court makes reference and to which I'll come presently, is to amend the CPR 19.8 claim form from the representative for the representative action to then specifically name the represented persons as claimants for the purposes of stage 2. Now, I accept,
Which might also raise limitations.
Which may
also raise limitation issues.
which may also raise limitation issues. I accept, but the position is not resolved, and indeed there are indications that the presence of the representative action has the effect of stopping the litigation clock for the represented persons.
Well, that's quite a big risk for, if I was one of these individual investors taking advice on this, I might think that was quite a big risk.
And my lady, for that reason, and really it's only for that reason, that those institutional investors who could obtain funding issued the multi-party proceedings on a protective basis. And that's why the effect of the judge's judgment is so devastating for those represented persons who are not parties to the multi-party proceedings. Because if it's right, and we say it is, that for them it's the representative action or nothing, and if the concerns that motivated commencement of the protective multi-party proceedings on limitation are well founded, then those investors are left without redress.
Well, that just seems to me to be unreal. I mean, if they've got a claim and they want to bring a claim, then they can bring a claim. They can either do it individually or they can do it as a group by one route or another. They could either apply to join the multi-party proceedings. I mean, one of the things that is very puzzling about all this is, as I said earlier on, if one sort of stands back from it and just looking at the costs arrangement, the idea appears to be that each claimant will bear its proportionate share of the overall costs. Now, if you've got hundreds of them, as you have here, their share of the overall costs is a pretty modest amount of money. And the terms on which you have to, or you're entitled to sign up, are that you provide some sort of guarantee or whatever. There's no evidence that the retail investors have been deprived from the opportunity of joining the multi-party proceedings because they can't afford, for example, to provide some sort of guarantee or anything of that kind. And normally what would normally happen in these sort of cases is that people would join together by one route or another and bear a proportionate share of the overall costs, which might be no more than a couple of £100 or something like that, depending on how many of them there are and how long the litigation lasts. But so saying that the retail investors are deprived of justice seems to me to be, putting it bluntly, Mr. Chapman, going at some.
Well, my lord, I'll come to the evidence in due course, but so the effect of the evidence is that exactly as I've described it, is that for practical purposes, the cost benefit and the risk benefit analysis struck by smaller investors, not just retail investors, but smaller investors, but within that retail investors in particular, is effectively to make the multi-party proceedings unviable. And that includes considerations such as the heavy front-loading of costs in the multi-party proceedings, and together with the cost risks and the time and trouble of advancing your own individual case at an early stage before the common issues on liability have been determined. Whereas we say the balance is struck completely differently when it comes to the representative action.
Well, if you proceed by way of multi-party proceedings, as happened in the other Section 90A Schedule 10 cases in the financial list, you would, what seems to be become quite frequent is some sort of sampling procedure or something of that kind in relation to a handful of claimants. I mean, the latest I think is Mr. Justice Michael Green's case. There seemed to have been a very small number of sample claimants. And he struck out the claim in relation to one group of sample, the three different groups. But I think there was only one claimant who or there might have been three in that group. So you simply argue for saying, well, in terms of reliance and causation and so forth, we'll have a sample of X number of claimants.
Could just building on that, you refer to the heavy loading of costs in multi-party proceedings. But if that is associated with sampling exercises and claimants required to plead individual claims, surely that is a point that could be put to the judge in making case management decisions as to how to handle those proceedings. And if, for example, by including in your sampling exercise one or more retail investors, that risks those investors not being able to participate at all, isn't that something that a judge can consider?
Well, my lady, in theory, of course, the problem is that the retail investors, so to speak, have never got through the door.
Yes, but that's not, if I may say so, not necessarily the courts due to any action by the courts, and we don't have visibility on exactly why they're not getting through that door.
Well, I keep promising we'll come to the explanation that was given in the evidence as to why smaller investors take the commercially rational decision that they do, that the game is not worth the candle because of the structure of...
Sorry, is
that Mr. Leedham's witness statement?
Well, it's Mr. Leedham with the two claims advisors as well, which set out...
They don't give evidence about the specifics of these small investors. They just give generalised evidence about how they conduct things in the United States.
Well, they do give evidence as to the deterrent effect
well, never mind
and the
that.
lack of participation.
Do they give evidence about these retail investors? Because I thought the whole point was that these retail investors didn't appear until about a month before the hearing before the judge.
Well, that's also true, which is perhaps part of the explanation as to why their particular position is not dealt with as fulsomely as it might otherwise have been in the evidence. But it is addressed, and I will come to it. But one can see from the very fact that there are no retail investors in any of the current Section 90A claims, that in itself gives rise to, in our submission, a quite powerful inference that there must be a reason why retail investors are not participating in these Section 90A claims. And we've set out what the reasons and rationale for why retail investors and, importantly, smaller institutional investors are not participating in these claims. And that's, so to speak, an inescapable fact that there are no retail investors in any of the Section 90A claims being pursued. And there are no retail or smaller institutional investors in the multi-party proceedings here, but there are retail investors in the represented class, in the representative action. And one can go beyond that by way of additional colour and detail, but those are, in our submission, some pretty stark facts as to what the participation levels are of smaller investors, i.e. they are effectively not participating in multi-party proceedings in Section 90A claims, but they are participating and can secure funding to participate in a representative action here. So I was in Lloyd and its treatment of Emerald. The judgment then goes on to consider.
Can I just understand a little better? The Emerald is a price fixing case, so it would have raised pass-on issues. Presumably doesn't raise the same sorts of individualised issues as this case. It's nothing equivalent to reliance. Would it be fair to say it's more objective? Was the price fixed? Price was their pass-on? Would that be fair?
My lady, I think that would be fair. There are claimant-specific issues, in particular in terms of the individualised assessment of loss. But it is fair to say that that type of claim does not give rise to quite the same
That's for some of the issues that are considered in collective proceedings.
Yes, but it does. There's no reliance requirements. But that's why we say a closer analogy and analogies with Credential.
Well, can I understand that a bit better, please? Because in Credential, of course, ultimately it was found to be reflective loss. So
Yes.
Isn't it a case of I had so many shares at such a time and my proportionate share of the loss is therefore X?
Perhaps, although the individual shareholders would have to have shown reliance on the what was described as the tricky circular. So there was an individual issue that is a close relation.
And does Lord Leggett discuss how that would be addressed?
He doesn't. His discussion of Prudential is in paragraphs 47 and 48, as we've seen.
Oh, we've read it, yes.
Which I've drawn attention to, and I know my lady has read. When we come to see Prudential, which I'll come to immediately after we finish Lloyd, we can see how the issues were dealt with there. Let me see if I can take the next section in Lloyd relatively shortly. The next section is the Commonwealth cases, where Lord Leggett looks at Australia, Canada and New Zealand and identifies a broad and flexible approach to the representative action in those jurisdictions. And the court will understand why we say that that is helpful in the current case, given the report from Professor Higgins, which adds some further detail as to the experience in those jurisdictions. And I'll come perhaps to say one or two more things about that in the second main part of my submissions. But having then identified the Commonwealth experience, Lord Leggatt turns to the principles governing the use of the representative procedure. And in paragraph 67, going back to Bedford and Ellis, he identifies that the representative procedure represents a means of moving towards rather than away from justice. Before paragraph 68, agreeing with the courts in Australia, Canada and New Zealand that while a detailed legislative framework would be preferable, its absence outside the field of competition law is no reason to decline to apply or to interpret restrictively the representative rule. And with that introduction, Lord Leggatt moves next to the same interest requirement, which he identifies rightly as the one condition which must be satisfied before a representative claim may be begun or allowed to continue. And at paragraph 71, finds that the same interest phrase needs to be interpreted purposively.
Well, he deals with the point that divergent interests doesn't mean that there won't be the same interest if there are common interests, as it were.
My Lord, yes. And
same interest provision is satisfied. It's only when there are conflicting interests that it's not.
My Lord, yes. And of course, same interest is not an issue in this case,
No.
but it is nonetheless important in our submission in terms of general approach to see how Lord Leggatt deals with that requirement. And having then dealt with the jurisdictional requirement, he moves at paragraph 75 to the issue of the court's discretion. And perhaps I can just invite the court to read paragraph 75, as obviously that's important. And of course, it's important to pick up from paragraph 75, as was done for my Lord Justice Nugee in Commission Recovery, that a consideration and application of the overriding objective is likely to militate in favour of the representative action continuing. Now, and I'll return to that. In terms of the other principles, just taking them relatively briefly, there's no requirement of consent, and that's with an eye to opt-out proceedings. But at the end of paragraph 77, we see it said that equally, if there are circumstances which make it appropriate to limit the representative class to persons who are positively opted into the litigation, it is open to the judge to make this a condition of representation. The procedure is entirely flexible in these respects. So opt-out or opt-in, both are available. Paragraph 78 deals with class definition, and we see again that in the same way as opt-in and opt-out can be dealt with as a matter of the court's discretion, it's said in paragraph 78 that the adequacy of the definition is a matter which goes to the court's discretion in deciding just and convenient to allow the claim to be continued on a representative basis.
It's interesting, Mr. Chapman, isn't it, that both of these points are put as the court's discretion deciding how best to manage the proceedings.
Yes.
I haven't seen that aspect in these proceedings.
Well, because, and this is really sort of jumping ahead to where I get to once we've looked at commission recovery in this court, when one's thinking about the exercise of the court's discretion in circumstances where the proceedings have been begun as a representative action as of right because the jurisdictional threshold has been met, what one's looking for in our submission is something in the form of a knockout blow that makes the continuation of the action on a representative basis inappropriate or unjust. And the type of examples one gets from the authorities, and I accept they're only examples, and it's in no way a closed class of example, are these types of matter. So that going to the structure of the action. So is there something wrong with the representative claimant itself? Is there something wrong with the action being opt-out or opt-in? Is there something wrong with the class definition? That's really the inquiry that the court should be embarking upon in the exercise of its discretion. And if there is something wrong, then one can look at remedying that by making an opt-out and opt-in, by redefining the class definition, and so on. But what one doesn't see here, or for that matter when we come to commission recovery, are the type of case management issues which really were the driving factors in the judge's decision below here.
What I suppose I'm struggling with a bit is the precise mechanism by which, I mean, Lord Leggett obviously contemplated that the court would review these matters, or could do so, and would determine whether it was appropriate to be opt-in, opt-out, what the class definition was. What's the mechanism for that? Because there isn't, it seems to me, a ready mechanism. The judge below was faced with a strikeout, effectively a strikeout application and a binary yes or no.
That's obviously right. The mechanism for dealing with these matters is through the exercise of the discretion. So, for example, if the class definition is hopelessly imprecise, to be unworkable, then that would be a good basis for exercising the discretion to bring the representative proceedings to a halt. You know, this simply won't work because your definition doesn't work, as it didn't in Emerald. And that would be the type of, as I've inelegantly described it, knockout blow that would be a good basis upon which to exercise the discretion to bring the proceedings completely to a halt. Now, short of that, if the basis of the challenge to the representative action was the definition of the class, one can see that by analogy to the position where a defect in a pleading might be amended, cured by an amendment, the court might, short of striking out the claim, say, your current definition does not work, but I might be minded to exercise my discretion to permit this claim to continue on a representative basis if you redefined the class. And actually, we'll come on to see, I keep promising we'll come on to see things, but we will come on to see. In Credential, the judge there said, and this would be another example of the exercise of the discretion, your declaratory relief doesn't work. It's not specific enough. But if you amend the declaratory relief that you seek, as the judge himself then suggested, then that would cure that defect, and I will permit the action to continue on a representative basis. But what one doesn't see, and frankly, you would expect to see if this was really an element to be considered in the exercise of discretion, are the type of case management concerns, which were really the only concerns being raised in this case. Because those case management concerns, deferring stage 2 issues, problems of recollection, litigation burden and so on, are an inevitable consequence of the bifurcated procedure that was being approved in Lloyd and Google. And we'd say, beyond being approved, recommended.
Well, those are all just specific examples, if you like, of the different aspects of the overriding objective. I mean, that's what the judge, for example, going back to paragraph 75 of Lloyd and Google, ensuring that the parties are on an equal footing. I mean, one of the reasons why the judge struck this out, the way it was proceeding meant the parties weren't on an equal footing because your client was effectively requiring the defendants to make all the running and not vouchsafing anything on the claimant side, as it were, of the costs burden. And equally, the judge, whether he was right or wrong is a different question, considered that ultimately the case might not be dealt with as expeditiously and fairly as it otherwise would be, through the representative route. So I think to suggest that his case management analyses, if I can put it that way, were out with what is permissible in terms of the court's discretion in this context is not correct.
Well, look, we say that the judge's analysis was infected by the wrong starting point, by his dismissal of the importance of Lloyd and Credential meant that he elevated those case management concerns to a prominence which they did not warrant and overlooked the guidance given in Lloyd as to how the balance is to be struck. And as I've indicated, what one is really searching for are the knockout blows, not matters of procedural preference, before one exercises the discretion to impose the frankly draconian remedy of striking out the action as a whole.
Yes, I mean, you can't get that concept of knockout blow from Lord Leggett's judgment, can you?
You can't. You can't quite get that far.
He's obviously not considering strikeout or anything like it.
No, but that's right. And equally, it would, in our submission to say the least, be surprising if Lord Leggett had not been alive, together with the other members of the Supreme Court, to the type of case management issues which really provide the rationale for the judge's approach here. Because they are inevitable consequences of adopting the approach that Lloyd Leggett is commending. So, my Lords and Ladies, just returning to the judgment, the next factor identified is liability. And then importantly, at Roman 6, the scope for claiming damages at paragraph 80. And paragraph 80 begins by identifying that it is not a bar to a representative claim that each represented person has in law a separate cause of action, nor that the relief claim consists of or includes damages or some other monetary relief. But then there are the cautionary notes that follow. So the potential for claiming damages in a representative action is, however, limited by the nature of the remedy of damages at common law. What limits the scope for claiming damages in representative proceedings is the compensatory principle on which damages for a civil wrong are awarded, with the object of putting the claimant as an individual in the same position as best money can do it, as if the wrong had not occurred. In the ordinary course, this necessitates an individualised assessment, which raises no common issue and cannot fairly or effectively be carried out without the participation in the proceedings of the individuals concerned. A representative action is therefore not a suitable vehicle for such an exercise. But then we have paragraph 81, which effectively sets out the answer to those difficulties in the form of the bifurcated process. And perhaps I can just invite the court to read paragraph 81, please. one sees from paragraph 81 two things in our submission. First, the identification of the bifurcated process, again by reference back to Credential, as being an available option of dealing with claims which give rise to individual issues on a representative basis through a bifurcated process, with the individual issues being addressed at stage 2, and also picking up on a submission which I addressed to the court earlier about what I've described as presently yet to be settled position on limitation. But there is, as the court will see, an indication or steer provided by the Supreme Court, again I accept entirely arbiter, as to what the limitation position might be, and how, based on both Credential and Moon and Atherton, represented persons could be permitted to bring their follow-on claims at stage 2, with the limitation clock, so as to speak, having been stopped by the commencement of the representative action. Now, in terms of disposal, Lord Leggatt then turns to the representative claim, in this case at section E of the judgment. And one sees at paragraph 84 that the Supreme Court could see no legitimate objection if the representative claim had been brought by Mr. Lloyd there to establish liability first, whether Google was in breach of the DPA, and if so, seeking a declaration that any member of the represented class who has suffered damage by reason of the breach is entitled to be paid compensation. And nor was it a difficulty or a problem at the end of that paragraph. One sees if only a few individuals were ultimately able to obtain compensation on the basis of a declaratory judgment. So the bifurcated process could in principle have worked in Lloyd had Mr. Lloyd sought to adopt it. But as we see at paragraph 85, Mr. Lloyd had decided not to. Effectively, Lord Leggatt suggesting because funding the proceedings could only be economic if pursuing separate damages claims on behalf of those individuals who opted into the second stage of the process would be economic, and it wasn't. But importantly, in principle, the bifurcated approach would have worked in Lloyd. So, my lords, my lady, that is for the time being what I propose to say about Lloyd. My much promised reference to Credential, which we saw referred to in Lloyd at paragraphs 47 and 48, is at tab 4 of the bundle. And we've seen the summary of the position conveniently provided in Lloyd of the position in Credential. And in terms of the judgment, I should draw attention to the discussion of the criteria for permitting a representative action to proceed, which begins at page 55 of the bundle at letter G. And over the page, one sees a heading discretion. And first of all, in the first paragraph in the heading discretion, we see reference to the limitation position, which we presently saw addressed in Lloyd. And then at H, perhaps an echo of some of the points being made by the defendants here and accepted by the judge, that it was perhaps objectionable that the effect of allowing the representative action to proceed will be to add numberless claims founded on fraud. The answer to which was that the allegations were being made once and were already there in the pleading. And of course that's the position here in terms of the common issue. The common issue in terms of liability, issuer liability, is the subject matter of the declaration sought by the representative claimant. I should also draw attention over the page at page 57 of the bundle, just above letter B, to another objection that was taken by the defendants in Credential, which is that if the claim had originally been formulated as a representative claim, the defendants might have wished to adduce evidence that no member of the class has suffered loss. And again, that objection was found to be misconceived. And then I think finally, at page 57 of the bundle, letter F, under the heading the form of the amendment, we see the point to which I referred a moment or so ago, where the judge effectively took issue with the formulation of the declaratory relief sought by way of the proposed amendments, but indicated that he would nonetheless permit the representative action to continue if the amendments were recast in the way that he suggested. And we see that what he suggests should be the case is that just below F, he says the practical effect of such a declaration would, it seems to me, to be no greater and no less than the effect of declarations. First, that the circular was tricky and misleading. Secondly, that the individual defendants conspired to procure its circulation in order to procure the passing of the relevant resolution. And thirdly, that in so doing, they conspired either to injure the plaintiff and the other shareholders at that date, or to commit an unlawful act, or to induce a breach of the first defendant company of its contractual duty to the shareholders. It would, I think, be better that those declarations which constitute the common element of any claim by any member of the class for damages for conspiracy should be spelt out. And my lords, my lady, will identify the parallels between the declarations being spelled out by the learned judge there and the declaratory relief on the common liability issues sought by the representative claimant in these proceedings. And we do say that it is important that the Supreme Court considered the decision in Credential to be an important decision and an example of how the bifurcated process might work in practice. And that in doing so, the Supreme Court did not say, well, of course, Credential was a case where the representative action was only sought to be brought at trial, so one need not worry about case management concerns, as the judge did. The Supreme Court did not say, even by way of cautionary note, Credential might be an example of how the bifurcated process could work, and could work on the type of facts very similar to the facts of the present case. But you've got to be jolly careful about using it there, because if you adopt it, you won't know anything about individual positions on reliance, or because you won't know the total value of the shareholder claims, or because there might be issues of the represented persons starting from a standing start after the declaratory relief has been obtained and once stage 2 commences. And in our submission, it really is very difficult indeed to identify much by way of any material distinction between Credential and its endorsement in Lloyd and the present case. Now that on the law brings me to commission recovery. Before turning to the decision of this court, it may be as well just to look at the first instance decision in Authorities Bundle Volume 2 at tab 22, please. Decision of Mr. Justice Robin Knowles. And I seek to take, I think, just 2 short points from this. The first, when it came to the exercise of the learned judge's discretion, at paragraph 78 to 81, at page 600 of the bundle, and having referred at paragraph 80 to Lloyd, the judge at paragraph 81 put it shortly: if the choice is this, i.e. the continuation of the representative action in that case or nothing, then better this. And we say, effectively, for at least some of the represented persons, the same choice falls to be made here. It's either the representative action or nothing. And the second point, perhaps just briefly over the page at 601, is to draw attention to the end note, where the judge ventured some observations as to the flexibility of the representative action and perhaps the growing need for its use or some other form of collective redress to provide access to justice in the modern world. And perhaps I can just invite the court to read paragraphs 91 to 94, please. And we say with respect that the judge's observations there are all of a piece with the approach of the Supreme Court in Lloyd as to emphasising the flexibility of the representative action and the scope for its deployment more widely. And that then brings us to the decision of this court upholding the decision of the judge to permit the representative action to continue, which is behind the next tab in the Authorities Bundle, tab 23. And the position in terms of Rule 19.8 is addressed from paragraph 26 and following, starting at page 612 of the bundle. And at paragraph 27, my Lord Justice Nugee sets out, by reference to Lloyd, something of the historical origins of the representative action, and identifies that, given that historical origin, it's perhaps not surprising that the rule finds its natural home in claims based on rights conferred on a class of people, such as rights of members of a company. And that's, of course, our case here. And then over the page at paragraph 29, the identification that, as we've seen, the only jurisdictional requirement for the application of the rule is the same interest requirement, and reference to what Lord Leggatt said about that in Lloyd. And perhaps more relevantly for present purposes at paragraph 30, that it is no impediment that members of the class all technically have separate causes of action. And that's obviously the case here, and one sees again reference to Credential and its reference in Lord Leggatt's judgment. And paragraph 31, the representative action finds its simplest application in claims for declaratory relief. And again, if I invite the court just to read the rest of that paragraph, please. So, of course, it's declaratory relief that the representative claimant seeks here. It is right, of course, that at paragraphs 32 and 33, consistent with Lloyd, some difficulties with claims for monetary relief and damages are identified. Before at paragraph 34, reference is made to the bifurcated approach. And again, the reference in Lloyd to Credential and to Credential being important in demonstrating the potential for such a process, i.e. the bifurcated process. And then reference at paragraph 35 to paragraph 84, forgive me, in Lloyd, whereas we saw there was no legitimate objection to the representative claim in principle having been brought in a bifurcated approach in Lloyd. And then and of course, again, we say all of the points raised by judge here and relied upon by the defendants could equally have applied in Lloyd itself, where, as we've seen recorded here, the Supreme Court saw no difficulty in principle in that claim having proceeded on a bifurcated process. Paragraphs 36 and 37 deal with slightly different points about the recovery of damages before paragraph 38 returns to the question of discretion. And we see cited there paragraph 75 from Lloyd, which we've already looked at. Now, in terms of commission recovery itself, one objection taken to the continuation of the representative claim in that case was a pleading point, namely that there should be an individualised pleading of each represented person's claim. And although that wasn't pressed before this court, it seems, it is left at paragraph 69 of my Lord's judgment at page 622 of the bundle. In our submission, paragraph 69 is important because it addresses very many of the points upon which the judge relied, and consistent with, we say, Lloyd, suggests, with respect rightly, that matters such as in pleadings as to individualised assessment of each claim and other matters relating to each individual claimant's claim are stage 2 issues and are to be addressed down the line. What is important on the bifurcated approach is moving quickly and efficiently towards a determination of the stage 1 common issues, the declaratory relief that binds everyone, and how that then flows through in terms of the stage 2 issues and particular claims are matters to be addressed subsequently. Although I'll come on to make this point in a slightly different context, one can see how that might be particularly important in a Section 90A claim, whereas here the claim covers a number of pieces of published information over a period of time, and where it is at least possible, it might even be said probable, that even if all of the published information is found to have been misleading or to have contained omissions, liability may only attach to certain pieces of published information on the basis that PDMR knowledge is established in respect of some and not others. And the reason that then becomes important is because once you have the findings at stage 1 on the declaratory relief, what pieces of published information are we talking about? To which pieces of published information does liability under Section 90A actually attach? Then at stage 2, you can have a much more focused inquiry on the individual claims that focus only on those pieces of further information.
Well, indeed, that's one of the reasons to bifurcate in multi-party proceedings.
My lady, it is. It is. I accept that. And the general position in multi-party proceedings of these types, we would submit, is that realistically, there's never going to be a trial of every claimant's claim. If for no other reason than that would not be a efficient or prudent use of the court's resources. And so what the court has to do is devise a procedure for the efficient disposal of those claims. And bifurcation is the process that has most commonly been adopted. And we would suggest that in adopting bifurcation, the guiding principles really ought to be to ensure that the common, genuinely common issues, which bind everyone, so they bind the defendant and they bind all claimants or all members of the represented class, are determined first. And that claimant-specific issues are really matters to be held over to stage 2, so as to not to disrupt the efficient disposal of the genuinely common issues, which not only bind everyone, but can prove to be dispositive, and we would suggest also can lead to a more efficient stage 2. Now, I accept that all of those considerations are considerations that can inform and indeed have informed the case management decisions on the multi-party proceedings. But one's not here, or one shouldn't be engaging in some type of comparison exercise between one procedure and another. The starting point is you have a representative procedure, a representative claimant that has established, because it is not challenged, its entitlement to bring the representative action, and then an exercise of discretion as to whether there is anything in we would suggest the structure of the action that ought to mean that the court brings those proceedings to a halt.
You criticise the judge for adopting what I think you describe as a hierarchy, but aren't you proposing a reverse hierarchy where if the representative claimant chooses to bring representative action, then your submissions suggest that the court really should allow that to proceed unless there's some really compelling reason not to, which seems to be another hierarchy.
Well, I don't think we would put it as a hierarchy.
I'm sure you wouldn't use that term, but help me out here. Why is it that a representative action should be given priority, if you like? Why is it better?
Well, Melody, it's not so much in our submission of giving the representative action priority. It is recognising per Lloyd that this is an available procedure where the claimant, of course, has to meet the jurisdictional threshold, and here it does, to bring the claim. And then the court has a discretion to exercise as to whether to permit the representative action to continue as such. Now, given all of the advantages that Lloyd tells us a representative action carries with it, including specifically for claims similar to the present claims per Credential, which is specifically endorsed and identified as an important case. It's not a question of the court saying, well, one procedure is better than the other. It's the court, in the exercise of its discretion, asking whether a procedure that is otherwise available to the representative claimant, because it satisfies the jurisdictional test, which on its face is otherwise appropriate because there's no challenge to the class definition or to the declaratory relief being sought, should be deprived to it.
I haven't quite understood why you say it's not a question of comparing. It shouldn't be a question of comparing two sets of proceedings. You have issued two sets of proceedings. What's wrong with the court saying they're obviously not both going to trial? Should it be you, the claimants, who choose which to take forward to trial? Or should it be the court which decides which should be taken forward to
fact of the multi-party proceedings is a product of the considerations to which I've already made reference. And
Well, yes, but it can't, can it affect this question that you only issued them because you were worried about limitation? I mean, the fact is, you have issued 2 sets of proceedings. No, it's true that the second set at the moment is stayed. I'm balking at the suggestion that where you've done that, it's inappropriate for the court to decide, well, to compare the 2 sets. Let's put on one side the retail people for a moment, because they're only parties to the representative action, and that does raise slightly different questions. I understand that. You're going to come to that. Let's assume that the claimants, and this is true of the institutional claimants, I believe, are identical in both sets of proceedings. What is inappropriate about the court saying there are 2 types of collective proceedings that are being brought? It's a matter for the court in its discretion to decide which is more appropriate to try. What's wrong with that?
well, leaving the
retail to one side, because that is a very different argument.
yes,
The argument there is you can't in practice do it, and so these people are being cut out. Well, that's a quite different objection to the objection which you're on at the moment, which is we've started it, we should be allowed to finish it.
my lord, yes, and really it comes back to, in the exercise of the discretion, is there something structurally wrong in the representative action that renders it unjust or impracticable for that action to continue?
What's wrong
Well,
with the word
that runs you straight into my lady's point about hierarchy or reverse hierarchy. That's effectively giving the representative action a preference or a priority over anything else. And there's nothing to suggest that the discretion that is given to the court under CPR 19.8 is fettered in that way.
My lord,
One of the factors the court is obviously, seems to be entitled to take into account in determining whether or not to allow representative action to go ahead is if there is already a suitable alternative. And leaving aside the retail investors, rather like my lord, and I think probably my lady as well, I'm struggling to see what's wrong with the multi-party proceedings.
Can I just add to that, that when early on in his judgment, Lord Leggatt discusses the various alternatives, I don't think he covers multi-party proceedings of the kind that are in issue and stayed here. He's comparing group litigation, collective proceedings and representative actions.
my lady, that's right.
This is essentially a 4th kind.
My lady, that's right. Lord Leggatt does not specifically address what might be called quasi-group action that has been developed outside the formal group litigation order regime by the courts.
Yeah.
That's true.
Which I think actually, I sat on a case with Master of the Rolls quite recently, which discussed the multi-party proceedings
I mean,
and how the CPR works.
Lord Leggatt's, Lloyd and Google was a case where there was the class was enormous, wasn't it?
It was like 4 million or something.
Millions.
Millions.
4 million.
Not quite as big as in Merrick's, but it wasn't. It was
You had to own an iPhone, I think.
46 million.
That's 4 million, I think. 4 million, I think.
What in Google?
In Google, yes.
Yeah. And we're not in that territory at all. We're in the defined number of investors, defined by the number of shareholders.
My lord, that's right, and I think I'll come to the figures later, but I think it's in the order of 12,000 shareholders per company would be the maximum size of the class. But to come back to...
But the actual number of claimants is much smaller than that, isn't it?
Oh, it is.
It's in the hundreds.
Is it? Yeah, exactly.
These are people you've found who've signed up to your terms.
Yes, and the point, I know that my lord's question leaves the retail and small investors on one side, but of course we would say that the scope for the number of smaller investors to join if the representative action is permitted to continue is there, and one would anticipate that more would join if the representative action is able to continue.
And the costs regime that's been put in place so far as the claimants are concerned in between themselves, there's no reason why that couldn't apply equally in the multi-party proceedings, is there?
In principle, my lord, no, save that the funding that's been made available for the smaller investors for the representative action is not available
Leaving aside that point, you keep coming back to that point, and we'll see what the evidence is later. Leaving aside that point, so far as those institutional investors who are being funded, who are in both sets of proceedings are concerned, it makes no difference to them. Their cost liability will be the same either way, whichever of the two proceedings goes ahead.
To that extent, yes, in terms of legal costs and cost sharing in respect of those costs.
Yep.
In terms of the broader cost of the litigation, in terms of the management time that has to be devoted to, for example, completing questionnaires, if you're selected as a sample, to providing that wasn't really intended in any way to be critical or pejorative, but rather matter-of-factly in that.
Well, indeed, I mean, I think you're refreshingly honest about it. You really don't want the court to have the ability to impose that sort of discipline, and you're certainly open to make the submissions that has a chilling effect, as you do, but you've got to make them good.
You could quite, as my lady said, refreshingly honestly, you and your clients say in terms, well, we want to go down this representative route, because if it turns out we're wrong, then we're just lost on that, haven't incurred any other costs. If it turns out we're right, then by one route or another, we'll manage to ensure that this never goes any further, because we'll force through a settlement on the basis that if there are findings of fraud against the defendants and their directors, they won't have the stomach for a further fight. And that's essentially what this is all about.
I think
what you have not wanted to do, which is what's happened in the other cases under Section 90A, is to incur the costs of providing any disclosure or evidence or sampling in relation to the issues of reliance and causation.
my lord, that's correct for the reasons that have been given. That as to the burden that places and the disincentive that it provides to participation. And it's right. I don't think
you can speculate. You say disincentive to participation. There are other possible explanations that, in fact, it might be difficult for these claimants when it comes to it to actually establish reliance. That's another possible explanation.
I accept, my lady, it's another possible explanation, but you have, and I will come to the evidence as to the disincentives that the English procedure presents to participation. And I think coming back to my Lord Nugee's question, which I don't believe I've answered as yet, is that in circumstances where there are two sets of proceedings, it is tempting to the point of being inevitable that some form of comparison between the two is going to be made. And it's difficult to then leave on one side the participation and access to justice points, because the presence of the multi-party proceedings, brought as they have been for a particular reason, does not cut across or detract from what we say is the essential rationale of commercial actors acting rationally and reasonably as to why they would prefer one action over the other. That's the first point. The second is that, and this I'm afraid probably does come back to the participation access to justice point, is that if you are comparing two alternative procedures, they have to be available procedures. And if one, for practical purposes, is not available or as readily available, then that does make it, we say, difficult to draw comparisons between the two in terms of procedural advantages between one over the other.
That I think, as I said before, combines two quite separate points. The second point is there are people, the retail people and the small institutional investors, for whom the multi-party action in your submission is not really available. It's clearly available as a matter of law, but is not in practical terms available. But that seems to me to be an argument which says, if you compare the two, this is preferable because. But with the large institutional investors, those who are parties to both sets of proceedings, that's not an available argument. So your argument, I think, has to be, it's not for the court to say which of these two sets of proceedings do we think is preferable. It's for the claimants to say, we have chosen to bring representative proceedings, and unless there's some flaw in those proceedings or some reason why they shouldn't be allowed to go forward, we are entitled or should be entitled to take them forward because we think it's preferable to take them forward, regardless. It's not for the court to say you can have that one and not this one. It's for us to decide this is the proceedings we want to take forward. I think that is it. Is that a fair summary of your position? Or is that an unfair summary of your position?
No, I think it doesn't quite come to quite a stark position as I think Lloyd summarises the position. There is an available procedure in the form of the representative action, which carries with it all of the advantages that Lloyd tells us it has. And if the claimant has demonstrated that it's entitled to use that procedure, because of those advantages, the fact that another procedure might be available, and one assumes here as available on a practical basis as well as a legal basis, is something that can feature in the exercise of discretion. I think I have to accept that. But it can't weigh so heavily as a matter of procedural preference, so as to justify forestalling that procedural option which the claimant has otherwise shown it's entitled to use altogether. Because it's the advantages in the bifurcated representative action, which leave on one side providing access to justice to investors who otherwise wouldn't bring a claim at all, make access to redress more available even to those larger institutions that might otherwise be able to get funding for a multi-party proceeding. And in any event, as Lloyd tells us, and we'll come to see briefly in commission recovery, ordinarily when you look at the overriding objective and apply those features to the particular representative action in question, a consideration of the overriding objective will militate in favour of permitting the representative action to continue. Because, for example, one of the advantages of the bifurcated approach is that the parties and the court can move much more quickly and efficiently to a determination of the common issues, because they are the only issues in play at stage one. Now, I accept it would be said, you can try and persuade a court case management and multi-party action to do the same type of clean split, but the bifurcated representative action has that advantage built in. So one knows, importantly, that you have that advantage from the outset. So, for example, if you are an investor, you need to know before you bring your claim, or before you, in this case, opt into the representative action, what you're letting yourself in for. And
But the whole point about that's a very double-edged sword, with respect, Mr. Chapman, because I mean, in the other cases, not all of them, but some of them, including the ones my lady did, what has happened is there's been a sampling process and some advancement, if you like, not in respect of all the claims, but an identification of what, for example, in Mr. Justice Michael Green's latest case, Mr. Justice Leach's case rather, an identification of different classes of claimant who you know, claimants who've have had who directly relied on published information, claimants who've indirectly relied on publishing information, for example through their broker or whatever, and claimants who effectively rely upon market information as in the price and so forth, which is effectively an attempt to bring into English law the fraud on the market concept from the United States. And the judge was able to identify those, or the judges were able to identify those three categories at a case management stage in order to determine whether or not, for example, all the claimants who were before the court actually had a claim at all. And what happened in that case, I don't know whether it will come to the Court of Appeal, it may very well, but at the moment what the judge has done is to knock out effectively 60% of the total claimants on the basis that their claim was really a fraud on the market claim, which is not available as a matter of English law. Now that is classic robust case management, which is the whole point of the CPR. The whole point of the CPR was to take away the entitlement of parties to dictate to the court how cases would be case managed, and for the judges to take charge of case management. And it seems to me, at least arguably, that your approach reverses that process.
Well, Lord, we say it
may
does.
be right or wrong, but I mean, it does seem to me it has that effect.
Well, the key we would say to keep in mind is the use of two different procedures, and the court is still armed with its case management powers when case managing a bifurcated Lloyd type case. At stage one, it is case managing the stage one issues, the common issues. At stage two,
well, let's take an extreme case. I know it's an extreme case, but let's assume for the sake of argument that you had a trial of these declarations and the court found in your favour on all of those. But then when it got to stage two, it turned out that none of the claimants had actually relied on any of the published information at all. It was all just, as it were, they relied on the movement of the price, or they relied on other market matters, which, if Mr. Justice Leach is right, would mean that there wasn't in fact reliance as a matter of English law at all.
well,
That would have been a complete waste of time and money.
but my lord, that
I know it's an extreme example, but one could think of sort of variations on the theme, if you like.
well, and we saw in Lloyd that Lord Leggatt said it shouldn't matter, or shouldn't necessarily matter, if in the final analysis only very few of the representative persons had claims that sounded in a damages claim. But more than that, that's why there are advantages, which I touched upon earlier here, of the represented class being opt-in, because commercially rational actors are hardly likely to sign up to the represented class. Represented persons who in the final analysis are ultimately not going to have a claim. Now, that might be the case either because Mr. Justice Leach's decision is left undisturbed, although I understand that there is likely to be an appeal on reliance.
I don't know about that.
Mr. Justice Leach has refused permission to appeal at the
Yeah,
moment.
that's what I thought.
But as I understand it, leave from this court will be sought. There is also an equivalent application in the Standard Chartered case, which is due to be heard by Mr. Justice Michael Green. And so Mr. Justice Leach's decision is not yet the final word on the position of market and price reliance. But leave that on one side. Reliance is just one of the individual issues upon which, at stage 2, a represented person will have to succeed. It will have to succeed in demonstrating causation and their loss, and where it is an issue, they will have to demonstrate that their claim is not statute barred. They will have to demonstrate, as is often put in issue, that they have standing to bring the claim. But all of those are features of a bifurcated process of the type envisaged in Lloyd, that where there are individual issues upon which the claimant will ultimately have to succeed on an individual basis at a stage 2, they are issues upon which the claimant might fail and therefore ultimately not recover any damages. But the Supreme Court, as it were untroubled by the prospect that a bifurcated process that it envisaged being deployed might only lead to very few of the represented persons recovering loss. Now, the Supreme Court does not say so in terms, but the obvious rationale for that approach is that it is unlikely that commercially rational actors, as I said, would include within the represented class those who ultimately cannot tick the appropriate boxes on the claimant-specific issues at stage 2. Can I just return and complete where we are on commission recovery?
Yep.
We looked at paragraph 69, and then at paragraph 71 and following, my Lord Justice Nugee deals with the question of discretion and whether the court should direct that the representative claimant in that case should not act as a representative. And just picking up on a few points from these passages in the judgment, if I may, at paragraph 72, we effectively see an echo of the discussion that I was just having with my lords and my lady as to whether in fact any monetary relief would be obtained at stage 2 and whether that's a relevant factor to operate in the exercise of discretion. And one sees in paragraph 72 how that was dealt with, together with the fact that in that case the representative claimant had put forward no plan as to how stage 2 would in fact take place and lead to monetary judgments. And that was an echo in terms of the problems in how the declaratory relief would actually lead to the recovery of compensation on an individual basis, of a point that this court dealt with at paragraph 54 of the judgment on page 619. Where, having addressed, again, a limitation issue and the argument that limitation might bar the claims, at paragraph 54, again by reference to Lloyd, it was found that the fact that even if the representative claimant is right, there will remain issues which may require individual determination, and even if those issues go to liability and not just quantum, is not a bar to resolving common issues through a representative action. And then the point to which I was just making reference from Lloyd, that it does not matter how many members of the class will ultimately benefit from a declaration. So the position that my lords and my lady were just discussing with me was one that, as I've indicated, was addressed in Lloyd, and it was picked up again in commission recovery, and not found to be a bar to the representative action seeking declaratory relief. And then perhaps if we go back to where we were at paragraph 72 on page 623. And having identified the various points that were being made by the defendant in that case, which really echo some of the points that the court were just putting to me as to some of the difficulties that individual claimants might encounter at stage 2 in making use of and gaining value from a declaratory judgment in favour of the representative claimant. The court addresses those points at paragraph 74 and 75, leading to the conclusion at 76, which perhaps I just invite the court to read, please. So paragraph 74 is really the echo of the discussion that my lords and my lady were just having with me, and the answer to it, or at least the answer provided by the Court of Appeal in Commission Recovery, and it is the answer substantively which I've sought to give, albeit less elegantly than we see in paragraph 74. Paragraph 75 then addresses the question of discretion and notes that there is perhaps a difference between a challenge to the particular representative claimant and whether it is appropriate to act as such, and what the defendant was seeking to do in that case, and what the defendants on the judge's judgment have successfully done here, and that is under the guise of an application under CPR 19.82 for a defendant to be able to have the claim stopped in its tracks entirely. To which the answer given in that case, and we say the answer that should have been given in this, is that per Lloyd and the application of the overriding objective which militates in favour of allowing a claim, where practicable, to be continued as a representative action, rather than leaving members of the class to pursue claims individually, then that dictated the outcome as found by the judge in that case, namely that the representative action should continue.
Well, subject to your point about the retail investors, that's not the case here, is it? Because you've got the multi-party proceedings. Simply lift the stay. You have a case management conference after Christmas.
The stay will lift automatically if these proceedings remain struck out.
Yeah.
Yes, that's
So
right.
and then you can have a case management conference next term.
Well,
All these points about bifurcation can be made before the judge then.
well, my lord, they could, but I think I'd be repeating myself if I went back to the answer I've already sought to give on those questions. So, drawing the various threads together from the authorities, in our submission, 8 points of importance and relevance emerge from Lloyd, Credential and Commission Recovery. And they are as follows. First, the representative action is well established, if not often used, procedure existing for centuries. Second, it is a flexible tool of convenience to be used to advance the interests and administration of justice. Third, the threshold and only threshold jurisdictional requirement that must be met in order to invoke the procedure is the same interest requirement. Fourth, that requirement, the same interest requirement, must be given a purposive and pragmatic interpretation.
Sorry, it must be given.
A purposive and pragmatic interpretation, consistent with the flexibility and purpose of the procedure. Fifth, once the same interest requirement has been met, the court has a discretion as to whether to permit the representative action to continue. Sixthly, that discretion must be exercised by reference to the overriding objective, and often the requirements of the overriding objective will militate in favour of allowing the representative claim to continue. Seventh, by contrast, if a defendant is to be able to have the claim stopped in its tracks, in our submission, ordinarily there would have to be a successful challenge to the structure of the representative action itself, examples of which might include the suitability of the representative claimant acting as such, as was the challenge in part in commission recovery, problems with the definition of the class, see paragraph 78 in Lloyd, a Lloyd type case where the representative claimant seeks lowest common denominator damages that is bad as a matter of law, but perhaps where the common issues are not sufficiently dispositive. And eighthly and finally, that the representative persons have individual claims for damages requiring individual proof is not a bar to a representative action. Rather, in such circumstances, it may be appropriate to adopt a bifurcated process of having liability established first and then follow-on claims for damages tried subsequently. And in our submission, what you do not get from Lloyd or Credential or commission recovery, as frankly you would expect to if these were the type of powerful considerations as found by the judge, is any suggestion that there is anything wrong in principle with bifurcation, or in bifurcation effectively dictating the issues for stage 1 and stage 2, or anything wrong in adopting a different case management approach to the issues that might be applied in a multi-party action. And as I've said, in truth, in our submission there can be no such objection because the court retains all of its case management powers just within the two different types of procedure. My Lord, that's what I was proposing to say about the law under the first part of my submissions. Can I turn to why we say, as the second part of our submission, the representative action facilitates access to justice? And picking up on some of the answers I've sought to give to my Lord Justice Nugee, the existence of the multi-party proceedings here, of course, makes it tempting to undertake the comparative exercise between the representative procedure and the multi-party procedure. But embarking upon this in the way that he did, we say with respect, led the judge into error. Multi-party proceedings will always be available, in theory, as an alternative to the representative action. And that in itself, we would suggest, makes it unlikely that their theoretical availability ought ever to weigh heavily in the balance when exercising the discretion under Rule 19.8. Here there are, of course, such multi-party proceedings, brought only by certain institutional investors and only in order to guard against certain limitation concerns following the defendant's refusal to enter into standstill agreements. But the presence of those proceedings in our submission should not cloud the analysis of whether the representative action itself is appropriate and should be permitted to continue. And of course, we do say that to be a meaningful and fair comparison, the comparison must be made between two available alternatives. And if one route is in practice not available to particular claimants or potential claimants, then that is obviously, we suggest, a very important factor when it comes to the exercise of discretion. And it is at that stage that the relevant comparison is not between the representative action and the multi-party proceedings, but between the representative action and none. Now, having introduced this section of my submissions in that way, can I look at some of what we say are the benefits of the representative action and then why they would operate to facilitate access to justice in a way which the multi-party action denies? We have set this out in our skeleton, and I'm not going to, as the court would not wish me to, repeat what we said there. But in terms of the benefits, can I seek to identify what we say the key benefits of the representative action are? The first is that it reduces the burden of litigation at the initial stage. And the effect of that is that an investor can be a representative person, and receive the benefit of any findings on the common issues which are the subject of the declaratory relief, without themselves being required to provide detailed information for pleadings or disclosure, and without being at risk at the first stage of being selected as a test or sample claimant, who may have to provide still further pleadings, disclosure, and witness evidence. Second, that reduction in litigation burden saves time and expense. It saves time and expense in and of itself, but it saves time and expense in terms of what follows from the determination of the stage 1 common issues. If the representative claimant fails at stage 1, then that of course is an end of the matter, and no costs on either side and no court time is required to be expended on these stage 2 issues. By contrast, if liability is established on the declarations, then in our submission there is likely to be a settlement. We don't, with respect, quite characterise it as the claimants being able to force through a settlement, as my Lord the Chancellor suggested, but practical realities suggest that in that event there is likely to be a settlement.
The judge wasn't very persuaded by that on the evidence and said it hadn't really been explained.
Well, we suggest with respect that he erred there in that the experience, particularly in other jurisdictions, has been that settlements tend to be the rule. As it happens, on instructions, I can tell the court that commission recovery has since settled before getting to the stage 1 trial.
Well, and so some of the other cases before
Well, they have.
Without them being representative actions.
No,
I think G4S and Serco have both settled.
they have.
When you refer to liability being established, that's a shorthand. It's not actually an entirely accurate shorthand because
That's right.
this is not a split between liability and quantum.
No.
It's a split between are the defendants responsible for making dishonest statements and have the claimant suffered any loss as a result. And the second part of that may be, as we have briefly touched on, a very significant issue. Now, one can see that in a case like commission recovery, once one took a view on the underlying issues of law, there was very little else for the claimants to do because it was accepted that in the vast majority of what we call plain vanilla cases, if the claimant's legal case theory was correct, liability would follow. But as I understand it, I think I have less experience of these claims than either my lord or my lady, but as I understand it, simply establishing the defendants, the relevant person of the defendant did make statements or admit to make statements such as to trigger potential claim under Section 90 or Section 90A is only half the issue. The other half is have the claimant shown that they relied on that in any way. And there are various different ways in which you might or might not rely on it, some of which is touched on in the evidence. So that this, I don't find it surprising that the judge said getting to a success on stage one doesn't necessarily, it's not self-evident that it will lead to settlement, because there may be huge battles ahead at the stage two, which may or may not turn on individual matters, may turn on matters of principle such as Mr. Justice Leach's recent judgment.
Indeed, in order for a settlement to be achieved, you might think that it would be appropriate for the defendant to be able to gauge or have some idea of gauging the extent of its potential liability should the matter go to a stage 2 trial. And I think it's one of the things discussed in G4S and Serco that by doing a sampling exercise and trying to at least establish whether claimants are merely price reliant, whether they relied on specific statements, for example, all go to assist the defendants at least, and frankly the claimants, in understanding what the likely scale is. So when you're talking about facilitating settlement, you really mean settlement on what terms?
And that was why the judge said made the point he made about starting from a standing start. If you bifurcated totally, as opposed to having some sort of sampling and some sort of disclosure.
In answer to those questions, the first point is, of course, it's right that I'm using liability as a shorthand as a reference to the determination of common issues, and that, of course, the follow-on individualised issues are necessary ingredients in the cause of action. The second point is that the split which is sought here, it is the type of clean split between the genuinely common issues which will bind everyone and claimant-specific issues which will not. And the next point is that it was that type of split, and a split which left over issues relating to elements of the cause of action that would need to be proved by individual claimants, that was contemplated in Lloyd and also Credential. So that split, so to speak, is no objection to the representative action continuing in and of itself.
It's no bar, but it doesn't, you can't necessarily conclude from that it must be allowed to proceed. It doesn't prevent it going ahead.
Lady, I accept that, but given what's said about the advantages of proceeding in that way in Lloyd in terms of efficiency and access to justice and so forth, it is a matter which weighs in the scales in favour of the representative action continuing rather than bringing it to a halt. And another reason related to that is that the determinations of the common issues first ought to enable a more efficient determination of the stage 2 issues, because all parties in the court, so to speak, then know what they're aiming at, as opposed to, for example, a sampling process which has to necessarily try to accommodate various different alternative hypotheses as to what might be found on the common issues at trial 1. And so we do say...
Well, I think that might be exaggerated a little. I mean, the point Mr. Justice Leach made, which is I mean, whatever happens to his having struck out part of the claims, it may or may not go to the Court of Appeal. I follow that point, but quite a substantial part of his judgment dealt with the 19th century prospectus cases culminating in Edgington and Fitzmaurice, making the point that provided that reliance on the prospectus was part of the claimant's, or the plaintiff's thinking in making the investment. It didn't matter that there were all sorts of other things that went into the mix, and that's why you could, in that case, and I suspect you could do the same thing in this case, conceivably, you could divide up the claimants into groups if you had a sampling process, and you could say, well, there's that group of claimants who may have relied directly on the published information from the companies. There's that group of claimants who may have relied on information they got from third-party sources, such as their brokers or whatever, but it's the same information. And then there's a whole load of other people who may have just watched the price and the market information, and that may or may not be good reliance as a matter of English law. But at least if the sampling exercise has been engaged in, it assists not only the defendants to know the scope of, if you like, the scope of the or the potential scope of their ultimate liability, but it also helps the claimants.
Well, I mean, look, there are a number of responses to that. The first is the point I've already made, repeat at any length, as to this being an opt-in case where that there is thereby a filtering in terms of who becomes a represented person. The second point is that, of course, as I was indicating in an answer I was giving a few moments ago, reliance is only one of the claimant-specific issues which would have to be addressed at stage 2. Another is standing, another might be limitation.
Yeah.
But even within the reliance categories, the question is reliance on what? And where you have, as you do in these cases, and you do here, a case which extends over a number of years and a number of pieces of published information, in order for your samples to work effectively and to cover, so to speak, all the bases, you need to cover the various different hypothetical outcomes as to stage 1, as to which pieces of further information liability will attach to. And a claimant's position on reliance may have changed over time as well, which is another possibility. So while the courts have, in the multi-party actions, adopted a pragmatic response in trying to select samples which cover some of the hypothetical outcomes, there is a natural and obvious recognition of the limitations of the sampling process, in that you can't, without making the sampling process completely unmanageable, cover all of the potential hypothetical outcomes. Compare the position under the representative action, you embark upon the stage 2 inquiry knowing precisely the target that the parties and the court are aiming for. And that must be, in our submission, a much more efficient way
Well, you
of
say
proceeding.
efficient, but you're more or less guaranteeing, one thing you're doing pretty much is guaranteeing a stage 1 trial by that approach. Whereas one of the intended advantages of a sampling process is to facilitate settlement discussions at an earlier stage. Indeed, that must have happened in at least 2 cases which haven't gone to trial.
Well, I do not accept that you're guaranteeing that a stage 1 trial will be inevitable. If the parties are focused on the common issues and disclosure and witness statements going to the common issues, and therefore as to whether any liability is likely to attach at all, then that too is likely to have.
The difficulty of that submission, with respect, is unless and until the defendants know as it were, what the ballpark figures are for liability in terms of how much money your clients are looking for, how can they possibly settle it?
Well, that's why.
I mean, they're not going to settle. Nobody's going to settle on the basis, I admit I was a fraudster, and now prove you suffered a loss. I mean, that, you know, tactically, that's not how people behave in litigation, in my experience.
But that's why I've described the represented class as being an opt-in class as a benefit here, because the defendants and the claimants will know who is in the class, and, as was made clear, the representative claimant had offered to provide, on a without prejudice basis, the trading data for the members of the represented class.
But that does nothing, for example, to address the sort of point recently addressed by Mr. Justice Leach about price reliance.
Doesn't say anything about reliance at all. Anyway, is that a convenient moment? That clock is actually 2 minutes slow. And I think it is 1 o'clock. So
I know what it is.
2 o'clock.
Court rise if able.